Ono tak chvilku trvá, než se to nasetupuje. Tak. Takže teď jste v live session, co buď se zaměřujete, nebo klidně můžete být odmutovaní, ale lidi už se můžou hlásit tím pádem, když se někdo přihlásí, tak slyší a uvidí to, o čem se bavíte, nebo co jde. Tak jo, hodně štěstí, já budu vedle. A když tak vám píšu. Ten link potom se konec místí do té prezentace, kdyby vám nefungoval klikřím, kdyby se něco stalo, takže pana panička, jdeme s počítačem, my jsme zdravili.
Okay, hello, good morning, everyone. Welcome to Pride Business Forum webinar. Today, we will focus on issue of self-ID at the workplace. The issue of self-ID is following us for some time already, ever since we have put it into the questionnaire of LGBT plus workplace award, employer award. Then you started to ask us, what does it mean? How can we self-ID people who are LGBTIQ in the workplace? This is against the law, and so on and so forth. And we are very fortunate that Alan and Overy, the member of Pride Business Forum, is an expert in the field, and we agreed to put together this session to actually discuss pros and cons of allowing LGBTIQ people to self-ID in the workplace, and how to actually do it so it's in accordance with the Czech and EU legislation. And I'm very happy that Martin and Victor will be with us today. And we will go through all these issues with them. Before I give them a floor, I would just like to invite you all to our annual conference, Pride Business Forum annual conference, that it's titled Taste for Equality this year, and it's taking place on 22nd of June in Prague Marriott Hotel. It starts in the morning at 9 o'clock and ends in the evening. Those of you who participated already in the previous years, it is a great opportunity to touch base on the new trends in the field of workplace equality, but also go back to basics and remind ourselves why we are focusing on workplace equality in relations with LGBTIQ employees. We will have a great speakers. As we speak, we are actually rolling out the speakers and the program. We will have a great breakout sessions in the afternoon, and of course there will be plenty of opportunity to network. So I urge you to register. Those of you who haven't done it yet, you can do it on our website, pridebusinessforum.com. Okay, I think this is all from me. I would like to thank you, Alan, and thank Alan and Overy and Martin and Victor to be with us and to carry on this session. And now I am actually giving the floor to you to continue.
Thank you, Czeslaw. Welcome to our seminar. Good morning. Let me introduce myself. I'm Martin Chanek, and I'm Senior Associate at Alan & Overy, and one of my field is also GDPR, and that is the reason why I'm here. And the second reason why I'm here, I'm active in DEI and Pride Business Forum. So this is something which merged together, and which is one of my passion. And I'm here with my colleague Victor, who is an expert in employment law and GDPR as well. So he's the right person to be with me today. So first of all, I would like to give you some housekeeping rules. First of all, please know that this webinar is being recorded. And you have option to ask any questions during the seminar, and we'll try to respond as much questions as possible in the end of the webinar. this is quite an interesting topic, and we are receiving many requests for information from our clients, and I think that it will be helpful for you to know some information, some legal grounds for collecting of sensitive data such as sexual orientation or other categories which we will discuss. And first of all, we are really interested how often do you deal with this topic, and we prepared some questions for you or some polling for you, and then we can use the data also for our future activity in this area. So first question is your company currently collecting DNI data? And if so, we are really interested, what is the main reason why you collect the data, whether it's like legal obligation, whether it's forced by your parent company, or there are some options for you. So we'll give you we'll leave to you some couple of minutes to respond. Okay, I think couple of seconds and we will have results. Okay. Still, as I can see, most of you is currently collecting DNI data already. We will discuss whether you are doing it right. And the main reason, according to the poll, is that you are interested in how your company is inclusive, and I think that's good news, because there are many companies which are not doing it at the moment, and which are doing only because of legal obligations to be implemented soon. So good news, and it's really very interesting result. So. Perhaps we can start with our presentation. First of all, it's and this is connected also to our poll. Is the reason why we are collecting DNI data. There are many reasons from a social perspective and also from legal perspective. At the moment, many companies we are dealing with are saying us we would like to know more about our employees. We would like to target our internal policies according to the results of our DNI surveys. We would like to focus on the well-being of our employees, and also and what is really important is that there are some statutory deficiencies in respect of minorities and LGBT community. And the DNI surveys and collecting of DNI data is really helpful when preparing, for example, collective agreements or internal policies. And this is one of our activities that we are helping companies to make their internal policies and collective agreements equal. So these are the main topics at the moment. However, this topic will be important for, I think, all companies at the market, almost all companies, mainly the big businesses over 250 employees, as the new directives came into force this year and will be effective gradually from 2024 till 2028, where almost all bigger companies will need to publish non-financial data. So even if this topic is not important for some companies at the moment, it's very likely that this topic will become an issue and will become more discussed at the market in the future. DNI data, it's like very broad. It's a very DNI as such is very broad topic, and it includes many areas. It's not only about the LGBT people. It's about gender. It's about race, ethnicity, gender identity, disability, religion, or also social background. As we will discuss with Victor, not all this data is sensitive, and that there are different approaches in respect of each category of data. I think the most sensitive data is like sexual orientation and race, ethnicity. For example, social background can be processed in an easier way than other categories. So this is something which will need to be covered or addressed in our presentation. And for the area of DNI can be like the most important legal regulations are from labor law perspective and GDPR. And first of all, Victor will tell us more about the regulation from the perspective of labor law.
Thank you. Good morning, everyone. Again, I will follow up on what Martin was talking about with some legal perspective, and so to introduce the problematics, the collection of DNI data with respect to employees, with respect to candidates, is actually covered by two separate regulations. It's employment regulation in the labor code and in the Act on Employment, and also in the GDPR. To be honest, it's a bit of a complex matter to grasp, because those two regulations actually overlap. And to be honest, the employment regulation would not be actually necessary from my point of view. It comes to the same conclusions as the GDPR one, but only in a non-very systematic manner. It imposes some general bans on collection of some data from employees, but it does so in a very non-systematic manner. While the GDPR actually provides for complex, coherent regulation of the whole subject matter, the data protection of data subjects, including the employees. That being said, the employment regulation does exist, needs to be accounted for, and there are actually separate sanctions that can be imposed for its breach, which can be imposed by the State Labor Inspection Office. I think they can impose a fine up to 1 million Czech crowns for breach of these employment regulations, on top of any fines that can be imposed by the Office for Personal Data Protection under the GDPR. So I'll start with the first restrictive provision, which is stipulated in the Labor Code, which is section 316, paragraph 4 of the Labor Code, which states that the employer may not require or obtain through third parties any information that is not directly relating to the employment relationship. And actually, the section also stipulates some list of categories of data that can never be required, and some information that can sometimes be required. For example, I have listed them on the slide. For example, sexual orientation, ethnic origin, or church membership may never be required, while, for example, pregnancy or criminal records can be required if there's some legitimate reason related to the performance work, or if it is stipulated by law. And as you can see, this provision actually stipulates a restriction on collection of DNI data, because a lot of DNI data will fall into these categories. It will also fall into the general category that the employer does not usually need DNA data for. It's not directly relating to the employment relationship usually. Because, as Martin said, the DNA data are usually collected for other reasons, for some rectification of the statutory deficiencies, to target some well-being, but it's not usually directly related to the performance of work. And as you can see, actually, some of these data are explicitly listed in the provisions, such as the sexual orientation or the origin. So that being said, this provision forbids that the employer requires such information. And our interpretation is that such information can be given voluntarily based on consent, which is a bit of a liberal interpretation. You can find opinions to the contrary that it cannot be actually given also voluntarily. And also, of course, consent, as many of you will know, is problematic in the employment context, which I will talk about in the next slides.
Mhm.
But let's just conclude this slide with the conclusion that it is possible sometimes, under some circumstances, to collect the DNI data.
Yeah, and it's good to hear because from my experience, many Czech companies are afraid of this section of the labor code. And I think that many internal lawyers advise in the opposite way, that
Yeah.
it's not possible at all. However, our more liberal interpretation of this provision is that it's indeed possible. However, the consent is required.
Yeah, and under some specific circumstances, but we will talk about that.
Okay.
Also, very similar regulation exists with respect to candidates, and we can find it in the labor code, also in the Act on Employment. The provision in the labor code actually states that during the hiring process, the employer may require only data that are directly related to the conclusion of the employment contract, which, for example, it means that the employer can require some identification data, so we can identify the employee in the contract. He can require some contact data, so we can communicate with the candidate. He can require some education, the qualification, so we can assess whether the employee has or the candidate has the necessary skills for the job. But again, the employer does not really need to know the DNI data for conclusion of the employment contract. And Section 12 of the Act on Employment actually adds upon this with some list of information that can never be required. And as you can see, it also includes, for example, race, ethnic origin, or religion, again, typical examples of DNI data. And when you take those two provisions together, it's actually very similar to the section 316 that I talked about in the previous slide. And the layout is actually the same as with the section 316, and to get this data based on consent voluntarily, which again, with candidates, it may be even more difficult to have really voluntarily given consent with respect to this data, but we will talk about that on the next slide.
Maybe just a quick question: are there any occupations where you can request some, for example, religion data?
Yeah, there is actually. I mean, when you want to work in a church,
Yeah.
So then the church needs to know that whether you follow its religion. So that's one of the that's one of the exceptions when you can require church data, for example.
But I don't think there is any employment or any occupation where you can request, for example, sexual orientation.
Yeah, I cannot imagine such occupation. Okay. Maybe in the future there will be some, but.
Okay, so this is the situation right now. We'll see how it will change once the directive is implemented in Czech law, and probably we will have to, like the Czech Parliament will have to adopt some amendments to law to align this with
I'm curious about that.
Okay.
Yeah.
And this was the area of labor code.
Yeah.
And now we can start with the regulation of GDPR, which is more known to general public. That there is GDPR, and it's pretty sensitive to share certain data, to collect certain data. However, there are some ways how to collect DNI data in accordance with GDPR as well. Victor will talk more about specifics of consent and so on. I will just start with some general rules. From the perspective of GDPR, there is no category as such as employer. Employer, from the perspective of GDPR, is the controller of personal data. It's somebody who receives the data, who collects the data, stores data, and processes data For example, anonymized data for the purpose of some surveys, for the purpose of some reporting. So from this perspective, employer must always act as a controller and must follow the rules stipulated by GDPR for controllers. The main principle under GDPR is minimization of data. It means that you should collect, or you can collect only those data you need for the purpose for which they are collected. It means you need DNI data, for example, to do some non-financial reporting, and that's why you can ask only for those data which you need for that reporting or for that purpose. Or for example, you would like to implement some equal benefits at your workplace. You need to know what kind of benefits you should focus on. You can collect only those data which are necessary for this purpose. Always when you collect data or process data in general, there must be some legal basis. GDPR provides for many legal bases, for example, legal ground, consent, and so on. At the moment, we haven't found any legal ground for processing of data, because at the moment it's not legal requirement to collect to make some surveys or to collect data for the purpose of reporting. As I mentioned, it may change after the directive is implemented. The CSRD directive is implemented in Czech law, but at the moment the main legal ground on which you can based on which you can process data is consent, and Victoria talked more about what specifics the consent should have. And some of the data, or most of the DNI data, are considered to be special categories of personal data, and there are many specific obligations in respect of those data. Also, we will also talk more about the other compliance requirement. It means data protection impact assessment. It means that you should assess what kind of data you can process, what kind of information you should provide to people from which you collect data. You also have to provide to employees the privacy notice, in which you specify for which purpose and what data you are collecting, for example. And also you have to keep records on data processing, and it's a records where you specify what data and for which purpose you have collected, and what's your intention with those data. So this is something like general introduction, and Victor will talk more about specifics of special categories of data and consents.
Yeah, thank you. So as Martin said, any personal data processing needs a legal basis under the GDPR in order to be lawful, and these legal bases are specified in the GDPR. Any data processing needs a legal basis under Article 6. This applies to processing of all personal data. I've listed the possible legal bases on the slide, but usually in employment, the ones that are used is the performance of contract, legal obligation, or legitimate interest. These are commonly used in the employment context, but cannot really be used, as Martin said, with respect to DNI monitoring, with respect to collection of DNI data for making some reports, for making some statistics. And furthermore, also legal basis under Article 9 is needed if there is processing of special categories of personal data, which is a lot of DNI data, because by definition, special categories are, for example, racial or ethnic origin. It's data concerning health or religious beliefs, or also sexual orientation or sexual life of a person. And so, as you can see, all of the DNI data will actually fall under those special categories definition of personal data. So first, it needs to be, we need to find some legal base under Article 9 to actually so we can actually do some processing of such DNA data. And again, I listed some legal bases under the Article 9, not all of them, but most of the legal bases cannot be used in the Czech context for processing of DNA data. And we can come to the conclusion, actually, as Martin said, that only possible legal basis is explicit consent in the Czech Republic, also taking into account the employment regulation. And this might be different in other countries because GDPR allows for some local differences in this matter, but explicit consent is actually the only legal base that we found that can be used.
Yeah, in the Czech Republic. I can imagine that in certain countries that there are some legal regulations under which you have to report some information, and that's different story because you can collect data based on this legal ground.
Yeah, because it's also I actually listed it on the slide as well. It's the legal base that when it is allowed by employment or social security law, that also needs to provide some guarantees to the data subjects, to the employees. Then it is possible, but it is not possible under Czech law.
Yeah.
Actually, Czech law doesn't allow it; it restricts it even more.
Okay.
So that's why we can go only with the explicit consent.
Mm-hmm.
And since we are already processing under consent under Article 9, is also the most suitable legal ground under Article 6. So which also when we take into account the employment regulation, so that's the conclusion that you can use only the consent with respect to processing of DNA data. And so with respect to the consent, GDPR, the relevant guidelines of the European Data Protection Board, also of the local data protection authorities, state that the consent must be freely given, specific, informed, and unambiguous. Under Article 7, this must apply to any consent given under GDPR, and also Article 9 with respect to processing of special categories of data states that the consent must be explicit. The problem in the employment context is the condition that the consent must be freely given. Because in employment context, there's some inherent imbalance of power between the employer, between the employee. So it is unlikely that the employee is actually able to deny the request for such consent without feeling any pressure or some fear of negative consequences if he doesn't give such consent.
Mm-hmm.
And that's the problem, because if the employee feels some kind of pressure into giving the consent, then the consent will not be freely given. If it will not be freely given, then it will be invalid, actually. Mm-hmm. So it will be an invalid legal ground under GDPR. And so any processing based on invalid legal ground is illegal. Yeah, so it is in breach of GDPR, and the controller can be posed to sanctions.
So what do you think if there is in a labor contract, employment contract, there is a provision saying we can collect any data, including DNA data? From my perspective, it wouldn't be a free consent, because otherwise you are obliged to sign the contract. And if it's there, I think it should be separate for this kind of data. Yeah,
that applies actually to all consents, not only in the employment context, but even more in the employment context.
Yeah.
Even if it wouldn't be in the contract, even if it would be on the separate document that the employer just gives you, for example, at your first day, I still think that would be problematic, because you would feel bit pressured to sign it, and also actually refusal to sign something like that is also some kind of information. So again, it gives pressure to the employees. So the only way out is to get the consent in such a way that there is no pressure, no pressure on the employee, actually. Okay. Which the employer will have to demonstrate that there is no pressure, no fear of negative consequences, and also that there are no negative consequences for employees who doesn't give such consent, who doesn't give their DNA data.
I think we will discuss later how it should be done correctly.
We have an example how it can be done. I mean, there might be some other ways, but we thought of one example that how it can be done, and yeah.
Yes, so there are other compliance obligations on GDPR.
Yeah, there are some further compliance steps that must be usually taken with processing DNI data. The first one would be to actually make a DPIA, which is data protection impact assessment, which is basically another document that you have to have for your records. And it's an additional assessment documentation that must be made, which describes the processing, identifies the risks, and also proposes some mitigating measures if the risks are high. And DPIA must be done generally when there is a high risk to the freedoms and to the rights of data subjects, in this case, the employees. And it is usually required, for example, when there's processing of sensitive data on a large scale, which exactly is what would happen if you would collect DNI data. And it must be done before the processing, so the DPIA should be done before any such monitoring starts. Also, the privacy notice, the employees must be informed about the DNI monitoring before it starts. And the employees usually already have the privacy notices because it's a general obligation, not only with respect to DNI data.
Yes, so, however, you have to specify explicitly that you are going to collect DNI data and for which purpose you are doing that.
Yeah, so usually what is sufficient is to just update the existing privacy notice, that because usually the employers have one or two privacy notices with respect to employees. Sometimes it is also a special privacy notice with respect to candidates, but you don't need to have a separate privacy notice just for DNI monitoring. It might be more practical to just update the existing one.
Yeah, but do I understand correctly that the privacy notice is not enough? You also need to you have to inform them that you are going to collect it based on on consent. So
it's actually two tools that come together because the consent also must be informed.
Yeah.
So you will inform the employees also with respect to consent, also in the privacy notice where they can find all the information in one place, actually.
Yeah, because when you collect data, for example, based on legal grounds that you need it for social security, you just need privacy notice, but you don't need the consent.
And also, when we are talking about the legal grounds, actually, so because you talk about the directive on financial reporting in Czech law, it is with respect to DPIA that you don't need to do DPIA when the processing must be done based on a legal obligation.
Okay.
So at least now, how is it in Czech law? You don't need to do a DPIA if it will be an obligation to the firms. So that might be relevant with respect to the DNI processing under the directives. Okay. And also, as with respect to all data, you need to maintain accurate records of data processing, which is general obligation. So, and
I think we could, as we already heard from Victor, of the labor aspect, labor law aspects, and GDPR aspects, we can just summarize what's necessary or what needs to be done before you start collecting and processing the data. I think that the main principle is that the data can be given only voluntarily. It means at the moment the employers are not able to request those data. It means it's up to the employees whether they will provide the information to employers, and it's up to their explicit consent. And it's pretty difficult to obtain free consent under GDPR or under a labor code, as this cannot be, for example, done generally. It must be done in respect of the specific data for specific purpose. And the consent, and it's pretty tricky that the consent can be withdrawn by the employer, by an employee, and that there is an issue what to do with the data when the consent is withdrawn. I don't know whether you have any comment right now or we can discuss later.
Yeah, I can just state it briefly that well, you should assess whether you have some other legal ground for processing of the data you already have. I mean the data that you already processed, there was a legal ground, it's lawful, that the data subject withdraws his consent. It doesn't affect the lawfulness of the previous processing that was made based on this consent. So that's okay. With respect to some future processing, yeah, you need to assess whether you have some other legal ground, and if you don't, then you should erase the data.
Yeah,
you should not process them anymore. It also depends on what does the data subject actually want. But usually when they withdraw the consent, they also want to delete the data. And also any reports that you have made based on the data will be usually aggregated based on aggregated data, and which will be anonymous. So it won't be personal data. So GDPR won't apply to any statistics to any graphs that you already have, because there will be no personal data. It will be some aggregated data based on all of your employees.
Yeah, because you cannot connect the information from statistics with certain employee. I think it would be different if you have only there is departments and you have only one employee in the department.
Then it probably would be personal data. But when we are talking about 100 employees or 1,000 employees, and you have only some numbers that I have, I don't know, 10% of that, 6% of that, and you cannot take any information about some specific individual from such numbers.
I think the main purpose for collecting of DNA data is usually this, that they are anonymized. So it means the employer processing data by anonymization them, and then they are used for survey for reporting and for some internal surveys. And
yeah, but what's important to actually remember that anonymization is also processing. So you also need a legal basis for it. So when you want to do such processing, you need legal basis for collection, for some storing of the information, and also legal basis for making the reports, for aggregation, for anonymization. Afterwards, it's anonymized data. It's not personal data anymore. You don't need anything. Actually, under GDPR, it's free to use. But before, you need those legal bases.
And I assume that the number of people who have access to those collected data, DNA data, should be as minimum as possible. For example,
that's a wider issue under the GDPR. That you need to have implemented some technical organizational measures with respect to all processing of personal data. You need to have a system that actually protects the data within the firm. So including also some need to know basis access to such data, and this is even more important when it comes to some sensitive data. When it comes to sensitive data, only like a restricted number of people should have access to them.
Yeah. Understood. So this is additional compliance requirement, extra and there are additional. So I can finish this.
I mean, I haven't listed all of the because then I would have to list the whole GDPR. I only listed the some that may be relevant with respect to processing of special categories of data, to processing of DPI. But of course, GDPR imposes many more obligations that are applicable to collecting of any data. So, but that's a general obligation for processing of any data.
Yeah, and I believe that the companies on the Czech market, they have pretty good knowledge of GDPR in general, and we are now focusing mainly on DNI data. And additional obligations before you start collecting DNI data would be to make DPIA, which is assessment, what kind of data for which purpose you are going to, what measures you should implement, and as mentioned by Victor, if there is a legal obligation, it shouldn't be done. But at the moment, as we mentioned, there is no legal ground, and DPIA would be generally required under GDPR. we must inform the employees or update the current privacy notices, informing employees that we are going to collect and process data, and also we have to specify what kind of processing and for which purpose we are going to process. And also we have to keep records. So I think this is some like general overview of what needs to be done before starting processing data. And now there is I think the practical part of our presentation, how this can be done to obtain the consent in a free and ambiguous way. Perhaps you have any ideas?
Yeah, this is actually an example from a case that we worked on, actually, that how this could work. At least we think that it could work based on under the Czech legislation. You could have an internal HR profile, database with profiles of employees, where the employees have some profiles, and in these profiles the employees can fill some information about them. I mean, some information would be either pre-filled or mandatory given, such as name or employment position, and there will be some blank spaces for employees to fill, which could be blank spaces also for DNI data. There will be no pressure. There cannot be any pressure to fill such blank spaces.
Mm-hmm.
I mean, there should be no prompts from the employer to fill such spaces, but it will be an option to fill such spaces, and nothing would happen if the employee wouldn't fill such space. But if he does, there should be also some prompt for a consent button. If he wants to fill this data, there should be it should be documented that the employee consents to collection of such data, and also with further processing, which will be usually the anonymization, aggregation of data, and making of some reports.
Mm-hmm. So if I can imagine such this HR system, it would have an option prefer not to say, must be there. Or
actually, prefer not to say is also some information about you. So it's also sensitive information.
Mm-hmm.
I think it's better than when you don't have to fill it at all.
Okay.
So no, actually no, prefer not to say. Just there's no prompt from the system if you don't fill it.
Okay, so there are fields like sexual orientation, ethnic origin, religion, and you are not forced by the system to put anything there. So you just can keep it blank, like you haven't touched that field.
Yeah, exactly like that. I mean, there will be some pre-filled fields like a name and stuff that would make up your profile, but there will be some information that can be filled. Doesn't have to be no prompt from the system if you don't fill it.
So if there is an asterisk, there is a node or asterisk that you don't have to, like the obligatory fields, name, surname, and the other are optional only.
Yeah, I think this will be voluntary given. In such system, I think it should be it will be voluntary enough to have the consent be valid actually for such processing. I think this could be problematic actually, but much more with respect to hiring of candidates, because I think the pressure to give some information, it might be even more problematic in the hiring process, because so for example, if the HR manager, you are on an interview, the HR manager comes to you, hey, fill out this form. There are also some sections,
optional information.
Some sections about optional information, DNA data. I think you would feel pressured to fill some data, and I don't think that would count as a valid consent. So you wouldn't process such data lawfully. I think that wouldn't work. But what actually could work, and this is more of an idea, if you have a portal on internet, some application portal where the employees can give their applications, where they usually give their applications, CV, names, you could have some optional section I don't know, on the on the right part of the page that you could click on. It wouldn't prompt you to, but it will be there, and which would contain information of which contains section of DNI data, but nobody would have access to information whether you actually filled such section. Nobody would have access to nobody could identify you with the information whether you actually filled the section or what you filled.
So it would be similar to internal HR system that there are some parts which you can keep blank and nobody knows about.
Yeah, yeah. I mean, at the end of the day, the data would get to the employer, but I think it would be good. It will be okay if the employer couldn't identify you with the data that you access. So the employer would only know that someone who was filling the application inputted some data, some DNA data, and then you employee could use it for statistics. But it will be a problem, for example, if you put the application and the HR manager would then know that, hey, you haven't filled this DNI part, that would create some pressure, and that would invalidate the consent.
Yeah, but from the perspective of employers and which are usually our clients, it will be difficult, or in practice, it's difficult to get sufficient DNI data. You know, for example, if it's optional, I can imagine that many candidates that do not fill that the data.
Yeah.
So from the practical perspective, now, and if there is no legal ground, it's really difficult.
Yeah, that's a general problem. That the more you protect someone's data, usually the utilization potential of such data is decreasing. So security is increasing, the protection is increasing, but the practical point of what you can do with those data actually decreases. The same is when you anonymize the data. I mean, when you for example randomize them, then you cannot usually do that much with them as you could before. But it helps protect the data.
Yeah, I think it's a general problem with GDPR.
Yeah.
So this is, I understand it's pretty sensitive, and it's always better to ask lawyers to look at the HR part, HR system, and also the hiring process before it's rolled out, because it can lead to some sanctions.
It can be very tricky to navigate.
Yeah. So this was a practical part, and now as we are a UK law firm, we have we have the opportunity to provide some comparison with UK. We understand from our UK colleagues that collection of DNI data is pretty regulated. In the UK, it's UK has like similar law as GDPR, like the main principles are similar. However, they have some acts, for example, Equality Act, which requires from the employers to provide statistics and some non-financial data already. So it's easier for them to collect data, and I understand that many companies in the UK, they publish DNI data. They do it. They have been doing it for some time already. So they are a bit advanced in this area. You can see example of how what data are usually published or included in statistics. This is the statistic of our London office, and I think it's pretty interesting to have such data, because then you can focus on areas in which you are not diverse or inclusive, and it's really helpful for HR people and the company as such to have such data. So for example, UK is one of the example where the DNI collecting of DNI data is easier and is done in practice, and I believe that after the CSRD is in effect, this will come to the Czech Republic as well, and that's why the companies should start preparing already at the moment, because
when does it come to effect?
it's from 2024 for the companies which already published some non-financial data, but this is not so extensive from the perspective of DNI. It's usually on focus of environment at the moment, and gradually it will become the obligation of also the small and middle enterprises, SMEs, and in 2028 also the companies from third parties having some presence here will need to report some DNI data. So that's why the company should start preparing. As you can see, it's pretty tricky to get it right, and hopefully the Czech Republic will adopt legislation which will help companies to collect and process data in the right way. So this was an example. You can you are free to find the full report on our website of our law firm, and probably we will do the same in a couple of years.
Let's hope so.
I think that there are some that there is space for a couple of questions.
Yes.
Yeah, I think I discussed with one of our clients the question, which is pretty interesting, and it's like the sharing of data within the organization. For example, we collect some data here in Prague, and we would like to send it to London, to our headquarters, because they need it for their internal purposes, or they are just interested how inclusive we are. What are the conditions, or is it possible at all?
Well, this is a bit of a complex topic that could actually be just for a separate presentation, but just briefly, you can share data. What's important is to have some guarantees, so which is usually done in the contractual documentation. So you would have some data sharing agreement between the group companies, where it will be important to actually identify the roles of the companies, whether it will be controllers or joint controllers or separate controllers or control processor. I think usually with respect to such monitoring, it would probably be joint controllers, and also with respect to the recent case law, according to the European court, it's everyone is joint controllers. So probably it will be data sharing agreements between two joint controllers, and this might be very tricky actually, because UK is not part of the European Union, and the thing is that GDPR imposes other strict obligations for transferring data to out of European Union, out of European economic space area. Sorry, where you either have to have an adequacy decision from the Commission, European Commission, with respect to some state, which is basically a legislation act that allows you to transfer data under some conditions to the countries that have such adequacy decision, which I think UK actually does have. But this might be very tricky to other countries. For example, USA that doesn't have such adequacy decision, because there used to be one, but it was brought down by case law. I think it was 2 years ago in the summer, in decision in Schrems 2. Actually, Mr. Schrems is an activist that actually starts these cases to actually clear up some rights, and he achieved that the privacy shield that was the data transfer between US and European Union fell down actually. And currently there is none. No privacy shield. I think it's negotiated. There was some. I think there was a public statement that it's being negotiated. And I think only last week or this week, I read that the Facebook or Meta actually got a big penalty. I think 1.2 billion for transferring data to the US in breach of Schrems 2, in breach of the case law.
Yeah.
So it's very important to assess first whether it's possible to transfer data out of European Union.
Yeah,
And big sanctions are being imposed for it.
I also understand from our clients it's pretty difficult to get data to the US at the moment. So hopefully it will change. We have one question, and it's about marital status and processing of data on marital status. So the question is, what's about collection of marital status? In Czech Republic, it's de facto a collection of data regarding sexual orientation, since registered partnership can be only same sex, while marriage are limited to opposite sex.
Well, that's an interesting question. I mean, I think you need to collect data on marriages because of taxes.
Mm-hmm.
But I don't think it's also about the use of data. I don't think that the data that you collect for your tax purposes, for your accountant,
Mm-hmm.
then you can use those data for some reports.
Yeah.
Because I also, with respect to marriages, actually, because you don't need to know whether someone is or isn't married. It's not relevant for performance work. So I think employment, labor code would restrict this.
But at the same time, I think the issue is that there is a registered partnership. When you claim to your, if I say to your employee you are in a registered partnership, he can assume that you are your sexual orientation. So I think this can be considered as a sensitive kind of data.
I actually agree. I think there was some recent case law about implied personal data, which was similar to this. So then also the information about registration partnership would fall under the special categories of personal data.
So I would just to summarize our response.
Yeah.
I think that if an employer requests information regarding their marital status because of taxes, for example, they need it in their internal system for the financial people, they cannot use this information for any other purposes. They can use it only for this purpose, and this purpose is on legal ground because they need it. This is requested by bodies or authorities. But this information, for example, if you share this information with your financial people, this information shouldn't get to any other employees, to any other people within the firm. So this is the minimization of processing.
Also privacy by design.
Yeah. So when it's for legal purposes, the employer can request that, and you have to provide it. I think there are no tax reasons for registered partnership, or there are no. I think the only tax benefits are for married couples. So there is no reason, for example, to ask about civil partnership or registered partnership. And if you would like to have such information, for example, for DEI purposes or for any other purposes, you can get it only based on the consent, which have to comply with all those requirements we discussed.
What I talked about, actually. So information about registration partnership, registered partnership would be special category of data, restricted under the labor code, restricted under the GDPR and the Article 9 actually as well. So
but it's a pretty good question, because in the Czech Republic, like the difference between marriage and registered partnership, it's pretty obvious. And for example, when you show your ID in which you have written registered partnership, you disclose your sexual orientation at the same moment. So and it's the same issue with transgender people and their IDs.
That's widely discussed. Yeah.
Okay, so I think we don't have any further questions. So I think we can thank you for having you here and for watching us. And if you have any questions, regarding the GDPR, employment law, or DNI in general, we are here to help, and our contacts are at the presentation, and I think we can also share the presentation to people who are interested in the topic. So thank you once more, and have a good day.
Thank you.
Už můžeme mluvit? No, oni to vypli. Já jsem chtěl poděkovat. Tak.
Ještě tady máme Davida, ten nás podle mě slyší, tak můžeme.
Ano, já vás slyším.
Jo, tak jsem chtěl poděkovat, že to myslím bylo dobrý, ta účast byla relativně...
Ale stejně nás všichni pořád slyší, jenom jsem chtěla.
Ještě jsou tady nějací přihlášení. Tak já děkovačku vyřídím, i já vám děkuju za spolupráci a uvidíme se na dalších, brzo asi nějakých akcích, anebo na nějakých našich společných.
Tak 6.6. nejpozději.
Jo, nejpozději 6.6. dneska to potvrdím. Děkuju, mějte se hezky oba dva.
Tak jo, díky, mějte se.
Díky. Ahoj.
Ahoj.